All right, aloha and good morning, everybody. This is the September 25th, 2025 Land Use Commission meeting. This is a hybrid meeting, which is physically being held at the Leopapa a Kamehameha State Office Tower at 235 South Beartania Street, room 405, Honolulu, Hawaii, 96813. This meeting is also open to the public. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into the microphone. Before speaking, please state your name and identify yourself for the record. This is a hybrid meeting, so please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting, which will be posted to YouTube and used for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. So if you do not wish to be part of the public record, you should exit this meeting now. Please note that the question and answer feature on Zoom will only be monitored for signing up for public testimony, and all other communications will not be addressed or part of the meeting record. Communications can be emailed to our office at dbed.luc.web@hawaii.gov. I will also share with all participants that we will take breaks from time to time. So for the commissioners participating via Zoom, when I call your name, please indicate where you are attending this meeting and if there is anyone else over the age of 18 present with you. Okay, and once again, my name is Brian Lee from Hawaii, and I will from Oahu, and I will be serving as chair today. We currently have 9 seated commissioners, and along with me today are 2 members from Oahu, Commissioner Malkahele, and the other commissioner is not here yet. Commissioner Kuiki Kamakea Ohelo is not making it today. I was just been told. Okay, and then we have 1 member here from Maui, Commissioner Bruce U'u, and 1 member from Kauai, Commissioner Dan Giovanni. Are you by yourself?
By myself, and I'm over 18.
Oh, that's good. I'm not sure you're able to drink yet, but thanks for confirming you are by yourself. And also we have here 1 member in person from Hawaii Island, Nancy Carr Smith. And let's see if I see Miles Miyasato. Yes, he's there virtually from Hawaii Island. Commissioner Miyasato, are you there by yourself?
Yes, I am.
And I know that he is over 18, so and 21. So if you're later on tonight, you can party. Okay, Commissioner Ken Hayashida is absent today, as well as who is from Oahu, and also absent today and excused is Commissioner Michael Yamane from Kauai, and as earlier indicated, Commissioner Kuiki Okalani Kamakea Ohelo is also absent. So besides us in attendance today is the Land Use Commission Executive Officer Daniel Orodenker and LUC Chief Clerk Ariana Kwan, and with us virtually is our Land Use Commission Deputy Attorney General John Dubiel. Okay, thank you for joining us and being with us today. So again, court reporting transcriptions are being done from this Zoom recording. Now we're going to go to agenda item number 2. This is an informational briefing from the Environmental Review Program, ERP, a division of the Office of Planning and Sustainable Development, also known as OPSD. We last heard from OPSD/ERP at our November 7th, 2024 meeting, and today's presentation will serve as a helpful refresher as we prepare to review an upcoming environmental impact statement, also known as EISs. For public testimony, I will now recognize any written public testimony submitted in this matter. Ms. Kwan, has there been any written testimony submitted?
No, Mr. Chair.
Thank you, Ms. Kwan. Are there any members of the public that we wish to testify today on this matter?
Seeing none using the Q&A feature, Chair.
Thank you, Ms. Kwan. Okay, we'll now go into our presentations. Can I ask for the staff from ERP to introduce themselves and provide an estimate of the duration of your presentation?
Thank you, Chair, Vice Chair, Commissioners. I'm Mary Alice.
Oh, are you?
Also, I didn't have my microphone on. My apologies. I'm Mary Alice Evans, the Director of the Office of Planning and Sustainable Development, of which the Environmental Review Program is a key part of our larger program. So first, we'll do a little bit of background on ourselves as an introduction, and then we will be going into a PowerPoint presentation, which you have in your board packets and with additional information on the rules. And the way we'd like to present, with your permission, is that Tom and I will alternate, and then Ron Terry, who is a former environmental council member of very esteemed standing, and who was very helpful in drafting the rules update that we are now speaking to. So we'll be asking Ron to chime in from time to time, and he can also, on his own behalf, add comments whenever he feels that that would add clarification for your elucidation. Is that okay? Can I proceed?
Yes, thank you. Thank you, Director Evans. Please proceed with your presentation.
Okay, a little background about me. I've worked for the state for over 50 years as a planner, state of Hawaii, in a variety of different departments and with different planning missions. I started out working with low-income communities, Molokai, Nanakuli, Waimanalo, and Hilo, and had a wonderful opportunity to work with those communities on streamlining some of the state services. This was way back before computers and the opportunity to use automation to make those more accessible to people. So it was it's a big challenge, and it still is, but it's different now. After that, I went to the Office of State Planning, which was created in 1987, and worked on functional plans and on a team that worked on the Department of Hawaiian Homeland's land claim settlement and the OHA claim settlement. Did that for about 8 years. Then I worked on special education consent decree and land use planning and economic development. And then I went to DAGS as a deputy comptroller and learned an amazing amount about the state's procedures for ensuring that the work that the public-facing departments can move forward. After that, I went to work for the Office of Planning, which by that time was in the Department of Business, Economic Development, and Tourism. I reported to Abe Matsuda, who was the Land Use Division Administrator, who was the key point of contact for the Land Use Commission for those 8 years. Then I did a stint as 8 years as the DBED Deputy Director, and then went back to the Office of Planning as its director. So I'm going to turn that over to Tom Eisen, who has an equally interesting career with the state. Go ahead, Tom.
Thank you. Yes, Tom Eisen, career not only with the state of Hawaii, but with some of the counties here also. It's been over 20 years of public service, and mostly with the state, starting with the city and county of Honolulu, processing special management area permits and things like that back in the early 1990s. Relatively soon after that, transferred to the Office of State Planning and actually started working with Mary Alice quite a while ago. I was in the Coastal Zone Management Program at that time. And then actually after a reduction in force, I was transferred over to the Department of Health and worked there for a while, and then was picked up by the County of Maui Planning Director, who I had been working with in the role of the CZM program. So I was working there. What happened after that? Went to DLNR for a few years, processing conservation district use applications. Then went to DBED as a marine program specialist in the Ocean Resources branch. So where else have I been? ended up here. Well, actually, here has changed. Initially, here was the Office of Environmental Quality Control. And as I'll explain later, that became the Environmental Review Program of the Office of Planning and Sustainable Development. It's been close to 10 years now in this position. And then there was a time when I worked for a fairly large planning firm locally. So I've had a lot of opportunity for different perspectives at the land use planning regime. And it's all helped me still try to figure out what's going on.
And I'd like to ask Ron Terry to introduce himself to the commissioners with your permission.
Yes. Well, I went to UH Hilo, graduated from there in 19 blah blah blah, and I prepared about a dozen EISs and hundreds of EAs over the last 35 years in my profession. I forgot to mention I picked up a PhD at Louisiana State University and then came back to Hawaii. In addition to that, I've served on 3 different boards and commissions for 24 years total, starting with Marine and Coastal Management Advocacy Council. I can't even say it. It's very long. And then the Mauna Kea Management Board, which is the one that's most similar to what you folks are serving on. We were technically advisory, but advisory in name only. If the board disapproved a project, that project was basically dead. It would not advance to the president and to the regions. And then I got on the Environmental Council in 2014, I believe it was, at the request of Scott Glenn, who many of you know. Scott wanted me to help him rewrite the EIS rules, which had not been touched for, at that time, over 20 years. And we're getting a little stale, and we're not addressing, had systemic problems from long ago, and also had not advanced into the 21st century. So we spent 3 different years doing that intense public process. And I would say that Scott Onaunathone, an attorney, and myself were probably responsible for most of the writing. I give the lion's share credit to Scott, but with enormous help from OEQC staff and the UH Law School. And so I do have background on the current rules. There's only so much one can do by rule to improve and clarify the process. The statute is, of course, the basis of the rules, and we could not affect that. One of my questions that I sent and is in the agenda here deals with rules with the statute, and I do have some remarks about that later.
Oh, thank you, Director Evans, Mr. Eisen, and Mr. Terry for sharing your vast knowledge and experience with us today. Please proceed.
May I qualify that on my own behalf? I'm still learning, and I expect to be learning as long as I can still be breathing. So what we've done is Tom and I and Ron have discussed a way of moving through the material so that we you'll get to hear, more than one voice. So I'll go ahead and start out. In 2021, the legislature decided to move the Office of Environmental Quality Control from the Department of Health, where it had been for 50 years, something like that, over, excuse me, into the Office of Planning and Sustainable Development. And it seemed like a very logical move to me, and I was very welcoming of it because it complements work we do in our other programs. But of course, it's a big learning curve for me, not for Tom and not for Ron, but for me. So next slide. Okay. What we're going to do is first do an overview. Then we're going to talk about the environmental review triggers. Then we're going to go into the levels of review. We'll talk about resources and have time for question and answers. We've included a slide with questions, but that in no way limits what you might want to ask. So we'll try to move through this quickly to give more time for discussion if that's your preference. So Tom is going to take on the next slide. Good.
Okay, this slide captures some language from the findings and purpose section of Chapter 343, which is the statute that establishes the environmental review process. And there's a whole lot of words in this whole presentation, and we can get bogged down in looking at them in detail. But really, the intent here is with these two paragraphs is to show that there's two overarching aspects of Chapter 343. The first paragraph speaks to it being a disclosure process to facilitate good land use decision making. And the second paragraph speaks to it being a vehicle to support public participation in environmental consciousness. So this was language from the 70s. Maybe different words would be used today if they were establishing the program, but those are two very powerful purposes of Chapter 343 and the environmental review process that it speaks to.
Okay, next slide. Okay, we'll be covering today the process and roles and responsibilities and public participation and oversight. I'll probably say this about 50 times, so forgive me if I'm repetitive. 343 is a disclosure process, not a project decision-making process. It's not an approval of a permit. It is a process of disclosure, and therefore it is decided by the land use commissions and other agencies and boards on a technical review basis rather than the merits of the project itself. It'll inform you by the content, and you will make a decision, one, on the level of review that the project merits, and we'll go into what you will make that decision on. And you will then make, at the end of that, your review of an EA or a final EIS, usually it'll be a final EIS. You will make a decision about whether it meets the criteria in the law and the rules and meets those acceptability criteria. That only is a review disclosure process. At that point, the project applicant may go forward and have a request to the Land Use Commission for a district boundary amendment or special permit or other matter that comes before you. And at that point, it will be your role to make a decision on the merits based on your own rules, your Chapter 205 law and rules. So it's two different and I think sequential processes. So going back to our bullet points, a proposed action must hit a trigger in 343. It has to have one to apply before it goes to figuring out whether there's a level of review that applies to it. Here's something that I've learned. The word exemption gets thrown around a lot. Some people, when they hear it, think that an action is exempt from the law, 343. No, it's exempt within the law. It's a level of review that an agency and a board such as yourself can determine that something has a minimal, ordinary, everyday impact that is not a significant adverse impact. Agencies do these decisions all the time. They also develop lists of exempt actions that don't have ground disturbance. There is a guidance in the law that tells them what kinds of things can be, types of things, actions that can be exempt within Chapter 343. And then In the rules, there are two levels of exemption. One is they're so ordinary, like buying paper clips or paper for the office, that they don't need to be recorded. And then a second level of an exemption would be one where they want to record it, make it public, send it to the environmental notice for publication. And then the second one is an EA. If an agency thinks that an action is significant enough to deserve disclosure, but they anticipate that it'll have a finding of not significant impact, and a FONSI, then they may choose to do an EA. At the end of that, they may say, no, this was, the EA showed that it met one of the criteria for significant adverse impacts, and ask the applicant or the agency to move to an EIS. Or they may decide that the EA showed that there was no significant impact, and then they're going to accept that. Agencies must apply the significance criteria in determining the level of review, and we've got a list of those in a future slide. The proposing party is either an agency or an applicant. Applicants are normally private parties, property owners, landowners, home builders, developers, and agencies, as we'll go into in another, can be executive boards and commissions, state agencies, county agencies. The Land Use Commission can fall under the general term agency for the purposes of 343. And then agencies, but not OPSD, manage the review either as a proposing or determining agency, and that is the Land Use Commission may serve that role. Oh, certainly. I'm sorry, and my voice is a little bit froggy still. So I'm going to let Tom go into the core decisions around public participation and oversight.
Chair, can I interrupt for just a second? Are we going to hold questions or ask questions as we go, or what's suggested?
What would you prefer, Director Evans?
Commissioner Carr-Smith, I think some of your questions might get answered by our, further slides. So I think it might be more efficient to have us, move quickly through them.
Sounds
and
good.
then-
Thank you.
Could you give us an idea how long your presentation is so that we can hold our breath?
Less than an hour.
Yes. It could be a whole lot longer if conversation starts happening.
I would
Okay.
not suggest holding your breath.
Okay, thank you.
You might end up sounding like me.
So another key aspect of Chapter 343 is it describes responsibilities for our program, the Environmental Review Program. And that really is to promote the public participation in the overall process. And that's by publishing the environmental notice, which you may be familiar with. It announces the availability of new documents that are going through the process, and various other things get included in the environmental notice also. It's published on the 8th and 23rd of every month. We also maintain an online library of all the EAs and EISs and various other documents and determinations that are sent to us. There's thousands of items in these libraries, so there's a lot of information going back to the 70s. We're updating the GIS aspect of it. Hopefully that'll go back online real soon. Public participation in a specific project going through the process, there's public comment periods that follow the publication of the draft document, either a draft EA or a draft EIS. One thing, there is no comment period on final EAs, final EISs, or exemptions. That is an element of the statute and the rules, and it's often news to various people. So we let them know the process has opportunities for comment, but those are the opportunities. Another aspect of these comments that are submitted to us is the applicants must prepare a response to the timely submitted substantive comments on EAs and EISs. That's all described in detail in the rules. There's a statute and the rules, and this presentation kind of talks about the highlights of both the statute and the rules. You can go into a lot of detail, which we'll only do as appropriate in this presentation.
Ron, did you want to chime in on this one?
I think not. I'll let you know if I want to do this. I think I'll let you guys do your presentation, then I'll do those questions at the end and have you guys chime in.
It's a deal. Moving on.
Okay, so there are 9 or 13, depending how you count, statutory triggers for initiating that chapter, but they're embedded within chapter 343. And if an action hits one of these triggers, then chapter 343 applies. And well, depending how it applies, and some agency will be making the determination on how it applies, but various pathways of clearing the responsibilities will come into play. A later slide will demonstrate the pathways that are available. But these 9 triggers are key, because if something doesn't hit a trigger, it doesn't go through the EIS process. So that is a fact that is not always widely known in the general public. They think an EIS should just be done for everything or anything. And there are only certain things that essentially can go through the process. The most common trigger is the use of state or county lands or state or county funds. That essentially captures pretty much anything government does, but also private uses of public lands or funds. And there's another trigger that's highlighted in green. It's here, it's the reclassification of land classified as conservation district. That pretty much only applies to the LUC. So there's a trigger here specifically for you folks, but that doesn't mean that an action, a proposed action, could hit a different trigger and still fall in your plate essentially for being considered the agency that makes the determinations. So go on to.
So we wanted you to get an idea of kind of the relative frequency of the different types of review. So the large circle is all projects that have a trigger that makes them subject to Chapter 343. And that includes those exempt actions that I talked about that are minimal in impact, that an agency can make that determination. Then in the middle circle are the ones that an agency determines merit and environmental assessment. And you might see some of those, but it would be rare because many of the matters that come before you will have a potential adverse impact. And then finally, the smaller circle are those projects requiring an environmental impact. And as you look at the numbers for draft EAs, 71 draft EAs in 2024, 55 final, only 5 EIS prep notices, and only 1 EIS accepted. So you can see that at this point in time, preparation of an EIS is rare. And I think that speaks to external conditions that are beyond our control, the economy, the difficulty and cost of doing projects that will have those adverse impacts.
And I think actually Ron spoke to this in his introduction. He said he had written, I think, a dozen or so EISs and hundreds of EAs. So the level of magnitude for things that go through the EA process compared to the EIS process. And then with exemptions, it's even a whole order of magnitude beyond that. And again, as Mary Alice said, it's an exemption from the erstwhile requirement of preparing an EA. That's the core thing that you potentially could get exempted from.
Okay, this is a little dense, but I think it applies to the Land Use Commission. The term agency includes commissions of state and county governments. So the Land Use Commission, when you hear agency, you can be deemed an agency for purposes of 343. An applicant is going to be a corporation, a nonprofit, an individual that is going to be anybody that's not a state or county agency. So that'll never be the Land Use Commission. The Land Use Commission can serve as the approving agency. Approving agency is a general, broad term that initially receives and agrees to process a request for a discretionary permit. And almost all of the things that come before you are discretionary permits. And you're the first commission to which, or decision-making body to which, say, a DBA, or sometimes a special permit over 15 acres, are going to come to. So you will serve as that approving agency. And then normally you would not be a proposing or determining agency because you're not actually carrying out an action. You're making a decision on an action. But you will serve as an accepting authority if an EA is completed based on the level of review that you have determined is appropriate, and when they first apply to have you serve as the accepting agency. And at that point, your role so under action, you'll be looking at projects primarily rather than programs, because you're a land use decision-making agency. But we've including in the definition of action are programs as well. And so when you hear the term programmatic EIS, that's where that derives from. And it's generally an EIS that an agency decides to do to cover a broad program of actions. And it has recently been determined by the courts that a program that grants permits for instance, commercial boat operators is not exempt from 343. And that means that the agency that does that action will need to comply with 343, starting with a determination of what level of review is required. So I'm going to turn it over to Tom.
Okay. So yeah, there's a lot of words and detail in the statute, and it matters, so we give them to you, but don't want to get too lost in them. These terms, they're more content related, and they are generally considered by the entity that's preparing, let's say, an EIS. It goes into detail on what an effect is, whether it's primary, secondary, cumulative, because these are all aspects of a proposed action that need to be analyzed in an EA or an EIS. As a reviewer and essentially decider if the EIS was done adequately, it's good to have a working familiarity with these terms, because you need to decide if the EIS was properly prepared. So these terms are here, they're in the rules, they're in the statute. So we offer them as something to get familiar with, but we don't want to get bogged down in a detailed discussion of all those right now.
So for your, in your role as an approving agency, when you determine what level of review is appropriate when a petition comes to you by an applicant saying, you will be the first discretionary permit. So we now want to find out what level of disclosure we need to do. You're going to look at the criteria for significance that we've listed on this slide and that are also in the rules. And you'll notice that they focus on adverse and negative impacts. Before this was included in the rules, there wasn't a distinction between positive and beneficial impacts and adverse impacts, and sometimes that caused some confusion. But you'll see that these are, because they're listed, you'll be able to work through them as a checklist and decide whether, if any of them are relevant to the petition before you to determine the level of review, that then they must do an EIS. Is that correct, Tom?
Yes, yeah.
Yes. Okay. So this is your first set of review guidelines.
And they're written in a way that can be interpreted, and that ability to interpret was intentional for the agencies to make when they are analyzing whether a proposed action is likely to have a significant impact or not. And being able to be interpreted makes it subjective, so a lot of effort should go into it to be sure it's done well. Okay, next, so we have this flow chart on our website of the process. It looks a little intimidating, and we're not going to go step by step into it all, but right now the intent is to show that there's some questions at the beginning part with kind of this white background that are intended to tease out, is this proposed action properly in Chapter 343? And if so, which of the 3 levels of review are appropriate? There's the exemption level, which is the lightest gray and the fewer steps. There's the environmental assessment level, which is in the middle. And then across the bottom is the environmental impact statement level of review with more steps, more detail, because it's intended to do a deeper dive into more significant actions. Ron, you certainly can chime in on these process-related things because you interact with it as you see fit.
I don't know if I can read this, Tom.
Yeah, it is hard. It's really not meant to read. It's just meant to show that there is a process, there's a method to the madness. And at some point, it's appropriate. We can do deeper dives, but we can get really lost in the detail, and that's not the point for here. The next one, again, just for initial considerations, it is important to make sure that a proposed action is properly going through 343. So there's some questions here, again, to tease out. Does this proposal meet the definition of an action? And if so, it is a trigger hit. And then an interesting aspect is for applicant actions, there needs to be a discretionary approval. And often that just happens without any thought, and pretty much any approval request that would come to the Land Use Commission, there's a discretionary consent involved. But we do get cases, and a lot of people come to us to ask us questions when you get novel cases where it's hard to figure out some of these questions. So we sit and help agencies figure out what might be the case. We at the Environmental Review Program do not have the authority to make any determination, but we can support agency staff as they ponder the ideas on when things are there's often a lot of grayness involved and they have to make decisions. But the outcome of this initial consideration is really to determine if Chapter 343 applies, and if so, which pathway to clear the requirements: exemption, do an EA, or do an EIS. And this next slide, again, just shows that there are these pathways for an exemption and for an environmental assessment. There's some detail to it, but not as much detail as to the EIS process, which is on the bottom here. And certainly my general understanding is that most of the actions that have gone to the Land Use Commission have gone through the EIS process. It's not mandated that it has to be the EIS, but that often has been the decision. So the focus probably should be on EISs here, but it is certainly possible that an action could be presented to you and you could determine that an EA is the appropriate level of review. Again, that's all decided on a individual basis, and we're available to help agencies sort through this, but we don't have the authority to make any determination.
Tom, before you move on, I want you guys to note that at the end of each one of these pathways, there is a small hexagon in dotted lines, and it says judicial challenge, period. And so that means that an opponent of a project who feels that either the level of review was wrongly selected, or that the acceptability of the document was wrongly determined, have the ability to challenge the agency, and that could include the LUC, and it does from time to time, in the courts. And I think at this point, excuse me, that often goes to the environmental court, which is a special panel of judges that have volunteered within the judiciary to specialize in this area in addition to their other judicial duties. And so Scott Glenn and I were invited to provide this training that Tom helped us with in June to the environmental court judges, focusing for them on that endpoint where there's a judicial challenge. And as a side note, opponents of projects often will try to utilize this option when they're concerned that a disclosure process, if determined to be acceptable, might set up a project they're strongly opposed to for a positive decision on the first discretionary permit. So we're seeing more and more legal challenges posed to this process, the 343 process. And so they're now a fair body of legal precedents and decisions that also apply to 343 as well. Okay.
A similar point on the flow chart, the heavy black circles denote agency determinations. So at the beginning and the end of every pathway is an agency determination, and all agency determinations are legally challengeable. So I guess the idea is to use proper judgment and don't spend too much time in court. Okay.
Getting close to our last slide. Okay, this is really important for you. These are the 3 areas of technical review that the land use commissioners should apply to a final EIS that comes before you as part of a petition. The first one you'll be looking at is whether the EIS, I'm going to use the term EIS because you're not likely to see EAs, has followed the procedures in the law and the rules. That's kind of a checklist thing because they either followed them or they didn't. And you'll be able to determine that fairly quickly. The content requirements are also spelled out. And here's a point I want to make. Your content requirements for your DBA petitions follow 205. The content requirements for an EIS may be similar and overlapping, but they come from a different statutory authority. And you're going to have to apply the 343 content requirements when you're looking at the acceptability of an EIS, and then pivot to the 205 content requirements when you are looking at the actual petition for a decision on your part. So that's a tricky one because there's considerable overlap as far as I can tell. Then the third one is the one where I think Ron, Tom, and I all agree is where there can be gray area and has a lot of potential for legal challenges. And that is the law requires that all comments received in the comment periods must be responded to inappropriate and satisfactory to the accepting authority. So prior to the update of the rules, sometimes opponents of projects, when the project was still in the disclosure process, would send in 400 comments that were essentially identical or similar with different signatures. And it it got its own name, comment bombing, because it then added time and cost to completing this criteria for acceptability. Ron, I think, was instrumental in getting a streamlined way to respond to identical or similar comments so that they can now be, it is acceptable for an applicant to combine and have the same response to the same comment.
A batched response.
Yeah. So, um,
And
again,
I believe your board packet has the content requirements, which is pages and pages from the rules. If there, I think there's 16 specific paragraphs that indicate a section of an EIS that needs to be there. So there's a lot of detail in your board packet.
that's going to be more of a checklist, I think, in terms of legal challenges. You can, because you can point to where in the document that content requirement has been met. But that's not to say that, as my supervising AG always told me, if somebody wants to sue, they will. So it doesn't mean that, you won't see challenges to content and or procedure.
Okay, Mary Alice spoke to this before, but there are, it's possible to legally challenge agency determinations. And there's different time periods. This is all in the statute. But essentially EIS is, the acceptance of it is the biggest thing, can be challenged. And also the decision that an EIS is not required, that determination can be challenged. So there's a lot of opportunities for legal challenge. So the deputy attorney generals can be kept busy with this stuff.
Okay, and now these discussion questions came from Ron Terry. And they're actually, I think, Ron, would you agree that these are thought experiments that, can be answered, in different ways? Would you like to take over from here on the discussion questions?
Yeah, I've prepared, a little bit of thoughts about each one of them, and then I kind of want to open it up one after another to discussion. Um, and so we'll have a kind of discussion after each one of these, and hopefully we can get to it. I guess I have two questions to start with is, uh, would the commissioners want to ask about you folks' presentation at this point? And is there a need for a break? I see Dan yawning and
I don't think you're supposed to see that, but we'll take a break at 11 o'clock. So is that a good time for you, or should we take the break now?
for,
Ron?
for me, it's great. Yeah, anytime you guys want.
Okay, please go ahead. And I think we should we should take a little bit of time to ask some questions of the presentation, which I want to remind everyone can be found at the Land Use Commission website at luc.hawaii.gov. And it will be archived in the agendas and minutes link for the public to see. So at this time, I'm going to open it up to any questions from commissioners from what was presented so far. Commissioner Carr-Smith, did you have something or has it been answered?
I do have some questions. I wonder if we could drop the question screen so we can see the other commissioners. Thank you. Okay, if you want me to start. What determines who reviews an EIS? Which agency?
The way the law is written is the first agency that agrees to take on an application is considered the approving agency. So oftentimes there may only be one agency involved, and then it's just that agency. But in the case where there's multiple potential agency, it's the first agency that basically agrees to be involved. And the rules also provide the rare opportunity for us to do some things. If there cannot be a decision of which agency that is, then we can help influence the decision. But the idea is that agencies would sort it out for themselves. And the whole point is the EIS or the environmental review process should happen early in the decision-making process, so it's available for all the decision-making that follows. So that's why the idea is it's the first agency that will be making a discretionary consent.
Commissioner Carr-Smith, I actually had an opportunity to have an operational role in where there were 4 agencies that could potentially have served as the approving agency, and they couldn't make up their minds. And they went back and forth, and none of them wanted to do it. And so it went to the director of the Office of Planning and Sustainable Development to make that decision. And I did, and it worked out well. It was a Hawaii Island action from an applicant. And so the law and the rules have provided, a way to resolve that if no agency is, initially willing, and there's several agencies that could serve.
If I may, Dan Hardenker, Executive Officer. One of the things that, we're talking about the way the rules work, but from a practical standpoint, very often what happens is that the petitioner determines which discretionary permit that they want to get first. And that results in that particular agency being the accepting authority. You may have seen in the newspaper about the Maui project where the city and county has decided not to be the accepting authority for a project. That was because the petitioner made the decision that the first permit that they were going to come for was the district boundary amendment rather than the rezoning.
Okay, that makes sense. I'm not sure I totally understand yet. Hopefully I will. On the trigger slide that you had, it said triggers for EIS. Are those also triggers for EA? And then you go through the EA process, and then if there's all those yeses, then it drops down into the EIS?
Correct. It's the trigger for the whole process.
The whole
to
process,
get you
not
in the
just
door.
EIS.
If one of the, and then once you're in the door, you decide whether whether an EA is required or an exemption or an EIS. But yeah, those are triggers to go into the process.
Okay, so the triggers and the exemptions are the same for an EA and an EIS.
Yeah, to get into consideration, it's
That
those
process.
triggers are
Yeah.
the ones.
Okay.
Correct.
I was curious how often at LUC and the environmental review program work together, just since that's what we're talking
We are
about.
very reactive. Things get sent to us for publication. That's generally our involvement with an actual project going through the process. There's not a lot. I would say that in the scheme of things, there's other agencies that have a lot more business going on that relates to Chapter 343. There's some agencies that hardly ever do it. So you guys do some, but not a lot.
Right,
That's kind
right.
of in a relative sense,
Right.
how it seems to be.
So I guess if I may, I could ask the executive officer when an EIA is before us to approve or to consider, do you go to the ERP agency to get their input?
We, I'm not sure what you mean by input. It's up to the commission to make a determination on the sufficiency of the EA or the EIS. If we have questions with regard to technical aspects or whether or not, anything, we usually call up, ERP and, um, I mean, Environmental Protection Office and ask Tom in particular, how do we handle this particular situation? That doesn't happen very often. But there are situations where strange things occur. And the biggest problem that we usually have that results in us calling Tom is if there's a question with regard to publication or whether or not, for instance, what happens if somebody doesn't get their letter responded to, or what happens if someone requests an extension of time to respond to a document. Then we would look to Tom for advice.
Yes, most agencies, when they interact with us, it's actually not asking us questions or asking us for comment on the action. They're just submitting it to us for routine publication, and there's an interaction process for that, but it's very perfunctory as opposed, and we're a very small program and we don't have the capability to review and comment on all the EAs and EISs that are happening out there. It would be great if we did, but with current limitations, we don't typically give substantive comments on them. But if an agency has questions about a quirk of the process, we will help them figure that out. But most agencies that have experience with the process have figured out how it works for them.
Mhm.
But it's only strange cases. So I only hear about the outliers.
Right. Okay. Thank you. I was just trying to get a sense on how we tap into people that are experts in the field, and what that looks like. So I'm good for now. Thank you.
Okay, before Commissioner Kahele, I see Commissioner Giovanni's hand held, so we're gonna take his question and then we'll take a 10-minute break as soon as possible. Thank you. Commissioner Giovanni.
Thank you, Chair. I think I've unmuted myself. So I have a two-parter. I'd like first to ask the Mary Alice and the team to elaborate on one of the triggers. I think it's number 8, which is if the project proposes a wastewater treatment facility, a waste-to-energy facility, an oil refinery, or a power generation facility, including renewable energy greater than 5 megawatts. I don't know if I quoted that correctly, but could you elaborate on characterize that trigger for me a little bit? Then I have a question about it.
Thank you, Commissioner Giovanni. Let me frame it a little bit. These specific triggers were added because the public felt that these types of projects were especially at potential for adverse environmental impacts. And so even though they don't hit any of the other triggers, there's no, state or county lands or state or county monies involved, or any of the others, these ones that have a wastewater treatment plant, waste to energy, landfill, oil refinery, or electrical generating facility automatically are a trigger. These projects have to go through the 343 process. So that's just framing it. Did I answer the first half?
Yeah, I think you did. So let me ask you my second follow-on question, which is a hypothetical. So if a proposed project is, I'm going to be specific here. It might be helpful, it might be not. So you can generalize it if I'm too specific. But if a proposed project is for a renewable energy a solar power plant that is large, it would require hundreds of acres and produce tens of megawatts of power. And they require, and they want to put it on agricultural land, and so they want to come to the Land Use Commission for a special use permit to do that. Would that trigger the need for an EIS?
I believe it would.
Let me say that, so the words that are written down here, they don't include the asterisks. And in the statute and the rules, there's some language that can further refine this, and specifically with the electric generating facility, it has to be a fossil fueled plant over 5 megawatts. So if it's a pure solar plant,
Ooh, I learned something.
it presumably wouldn't meet the definition that is here and may not have any other triggers.
That's
So,
that's the heart of my question, whether is there a distinction between a fossil plant and a renewable plant that would exempt consideration of the trigger?
yeah, well, the statute has this language that further refines this. So it does specify it has to be fossil fueled for this trigger to apply.
Thank you very much. Nothing further.
Thank you. We'll now take a 10-minute break and we'll come back roughly around 11:10. So thank you, everybody. All right, it's 11:11 a.m. and we will be reconvening. And I believe that the ERP branch has a update and clarification.
Thank you, Commissioner. Thank you, Commissioner Giovanni. During the break, we were able to look up the actual definition in the statute that answers your question. And I thought it'd be helpful to read it out. It's very short. Would you mind? Good. Okay. In chapter 343-2 definitions, the definition of a power generating facility means a new fossil fueled electricity generating facility, comma, where the electrical output rating of the new equipment exceeds 5.0 megawatts, semicolon, or, and here's number 2, an expansion in generating capacity of an existing fossil fueled electricity generating facility where the incremental electrical output rating of the new equipment exceeds 5.0 megawatts. Thank you.
Commissioner Giovanni, is that helpful?
Get my mute off here. Yeah, that's helpful. Thank you.
Okay, thank you, Director Evans. And now we'll take Commissioner Kahele's question.
Thank you, Chair. I have a question on, well, actually, I may need some clarification first. So not all projects require an environmental impact statement. There may be projects that just may need an environmental assessment. Is that accurate?
It is accurate.
So you got to go through the environmental assessment process before they determine whether you get an EIS? No?
That used to be the process before the update in the rules. And that led to considerable duplication of effort and additional time and cost. So the rules were amended, and Ron Terry can chime in on this one, especially.
Actually, it was that took a statutory amendment to add the direct to EIS clause.
Okay, you want to expand on that, Tom, and then Ron can
In
jump in?
2012, the legislature provided a direct to EIS channel so that an applicant did not have to first prepare an EA. And if essentially both parties agreed that an EIS was likely to happen, they could go directly to EIS and bypass the EA process. So the agency can, the strange language in the rules, but the agency can allow the applicant to go direct to EIS if they figure that's the right thing to do.
And I'm sorry, when you refer to both parties, you're referring to
The applicant and the agent and the commission. So
one more question. on your criteria of significance, when is the or all of the EIS that's filed is required to do a Kapa'akai analysis, or only when there is an issue raised, whether there's sacred grounds or where it's going to have a significant impact to the Native Hawaiians' rights? Yeah,
Commissioner
I'm-
Cahelli, that is an excellent question.
Thank you.
And it's certainly the subject of lots of confusion, I think, at this point. And I'm going to start, and then Tom and Ron can correct me. So the Kapa'akai was a court decision that requires an analysis with 3 tests made by the decision-making agency in a decision-making proceeding. And it is not required in Chapter 343. Chapter 343, as a content requirement, requires a cultural impact assessment. Is that correct, Tom?
It actually doesn't even require that. It just requires consideration of whether cultural resources are being impacted, and if so, then present information speaking to that in the EA or EIS.
Ron, do you want to add to that?
Yeah, I would agree with Tom there. I'll add that there's been a number of attempts, legislative attempts through the last 30 years to require a cultural impact assessment in each and every EA and EIS. And for practical purposes, most legislators have felt this was not necessary because some EAs, I mean, it can literally be a parking lot in front of the 7-Eleven in Waikiki. And the EA can be a short process that takes, 6 months and $20,000. If you add a cultural impact assessment component with what at least the bills have included in it, you'd be adding another couple $100,000 to that $20,000 EA and a couple years of research. And people have felt that for major projects, you absolutely need to do that. For smaller projects that are sometimes the subject of an EA, that's an extraordinary burden to put on an applicant or agency. You folks mainly deal with applicants. You're dealing with corporations, with individuals, with other entities, but the large majority of 343 applies to agency actions. And so you're talking about agencies doing, small, relatively small things. And the laws and rules that help with those have been designed to make them flexible. And there's a word in NEPA that we don't use in, that's in the federal law on EISs. We don't use this in 343, but I love it. It's very short. It says count what counts. Okay, so don't expend enormous effort on things where there's a consensus that there's no impact. Should you do a multi-year bird study for your parking lot in Waikiki? Probably not. But there are parties out there who would say, "Oh, you should always do a big, long, longitudinally appropriate study of birds in the area." So one size fits all solutions are probably not appropriate for something that has such breadth of scope as 343.
Mr. Chair, if I may, this was actually a question that came up in my law class when I was teaching last semester. And the Kapa'akai analysis is something that the agency itself does. If you go back to what was said at the beginning about the EIS being a disclosure document, the applicant or petitioner needs to put in all of the information with regard to environmental impacts, which include cultural impact assessment, if there are cultural either activities or actual archaeological components involved. Now, that being said, you don't necessarily do a Kapaakai analysis when you're accepting an EIS. But when the project then comes to you for actual review, you need to do a Kapaakai analysis. And what I have in my role as executive officer told petitioners is that they should provide, the best thing to do is to do a cultural impact assessment that covers all the information that the agency would be required to look at to do a Kapaakai analysis, so that it doesn't have to do another cultural impact assessment when it comes in for the project. So the Kapaakai analysis is done at the project level, not at the EIS level. Although the EIS can be almost, I mean, you could actually say the EIS could be rejected if the information that you need to do the Kapaakai analysis is not contained in the document, because then it would not be a full disclosure document.
So Dan, and I'm sorry, Dan. So what are you saying, Dan, is that you need to do a cultural impact assessment?
If there are
Is that
cultural,
with the
yeah,
EA or is that with the EIS?
it's, well, with an EA, you're looking for a finding of no significant impact. So your analysis would be that there is nothing culturally significant as a result of the project that's being impacted. If you're moving into the EIS stage, you're going to have to do a cultural impact assessment, even if it's to say there's nothing here.
I got one question for Mary Alice. So if there's a disagreement, whether there's, well, an example, an EV that may have been overlooked, is that when the process regarding a judiciary challenge kicks in? Or, I'm not sure.
It sounds like Commissioner Kelly. So SHPD itself, that's the State Historic Preservation Division, has its own role, and it after a disclosure process, and the applicant moves to get its discretionary permits, then it's going to go to the State Historic Preservation Division and ask for, it provides them information on whether this is an area that has historically had EV burials, and other archaeological or even if they're structures that are historic, architectural resources. So I think a cultural impact assessment probably should touch on the historic uses of the property in the disclosure process, but it doesn't necessarily have to do that grid pattern archaeological inventory that SHPD requires. Tom and Ron, do you have any, want to correct that if I've got that wrong?
In an optimal situation, everything is known and disclosed as they're preparing the EIS. Now, whether that in fact is reality is a whole different question. And often things come to light besides the fact of a great effort to try to find out, things pop up later. An EIS is essentially a snapshot in time when it was done, the state of knowledge. And sometimes things come in to view after the EIS has been finished and accepted. So when the project is being analyzed for an approval, that is when kind of the I's have to be dotted and the T's crossed and everything make sure represents, the full body of knowledge that's known.
Okay.
What?
Okay,
Oh, I'm sorry, Dan. You done?
What I can say is that we actually have a project where we kind of ran into this problem. When you're doing the EIS, you do your archaeological and cultural impact assessment based on the information you have. You're supposed to go out to the community to find out if anybody knows anything and all the rest. If you're in, say, central Maui, where there is a lot of sand and there are probably a lot of burials, then you're going to have to recognize that you're probably going to find, you're probably going to find something. And that, if you fail to recognize that, then the EIS is probably flawed. And that's different from the project being flawed. Okay, but it's interesting the way the law works, because if you recognize that you're probably going to find something, then what happens is that we will, or the county will, put a requirement on the petitioner that there be an archaeologist or cultural resource person on site to watch what's happening. And then if they find something, the burial council gets involved with what you do, where you either re-intern them or do whatever. On the other hand, if you don't believe you're going to find anything, and that's what your EA or EIS says, and then all of a sudden you come across something, then it's the Historic Preservation Division that decides what you do. And that can stop a project, because it takes a while for the Historic Preservation Division to decide what kind of further analysis needs to be done, what kind of mitigation measures need to be taken, and all the rest.
And that was the next point I was gonna bring up, because there's projects out there, construction projects out there that apparently, after starting it, you realize, oh, there's an EV here. You know, after being told maybe in neighborhood board meetings, claim was, oh, we couldn't find anything, and now the project gets stalled. The rail project, you know, it got stalled, and only because they didn't do a great job. We went out there and meeting with the community, meeting with the kupuna out there, and finding out whether, you know, there was anything out there, and projects get stalled because, you know, there's and if it's done at the project level, then at that level they don't want to spend the money in doing one Kapakai analysis. But anyway, oh, you can't hear me? Oh, okay. So that's the reason why I brought up this issue about the Kapakai analysis. Projects get stalled, and later on finding out that there's some significance out there, whether the Hawaiian are getting impacted, whether there's EVs there. So anyway, thank you very much. Dan, you hit the nail right on the head. Projects get stalled, we don't work, and projects get now delayed out there, cost goes up. But anyway, just wanted to share that. Thank you. Thank you, Chair.
Thank you. Any other questions from commissioners? Commissioner Wu.
Yeah, thank you. Hawaiians never put headstones where they was buried, so it's a guess, obviously, and it's a calculated guess to a degree, right? And I know for a fact in Kahului they found burials a bunch, but the right next subdivision that built 50 homes on the 15 acres found none. So there is historical evidence that points that yes and no, but no one. But I get what the chair's director is saying. It's a high probability, but I understand the next project right next found none. And, again, I guess in a general area, you'd say yes. I would agree 100%. Cost comes into play. And somebody brought up the cost, the difference between EA and EAS. The question I would have, I've heard that, and maybe it's changed, and maybe I need clarity that, I heard public say, you might as well just do an EIS. I hear them suggest that strongly many times, and I had no idea that, you can be specific to an EA for the triggers that will constitute an EA, and it's separated by an EIS. And now after hearing the cost portion of what was mentioned prior, I can see that there is a burden. It's never talked about, right? oh, the burden, this, you should just do it to be you should do it as a, as a responsible builder or owner. You should just build it. And I think we're facing part of the consequences when we're not receiving. I hope we spend time reviewing on EIS. And if we don't, we all in trouble right now. But after looking and reading and you guys going through the process, I would not want to do one when it's open to constant questions that you gotta have to respond to. And I like that you put it in buckets, but to be fair, it should be, if you get significant questions, you should get significant responses. Not when you get questions and then you gotta get significant responses. I think the table is turned not in fairness to the applicant. It's not, because they burden all the costs. They burden, everything that's needed to a degree. And when it's written, and here's my question. In a process of creating the EIS and the protection of the environment, we seem to separate it from being humans. It's a human element and then it's the environmental element. Yeah. So we cannot include the human portion of it with the environmental portion, or is that inclusionary or not? And if the intent of creating this EA process was to protect the environment, which we're all for, and how is it working now? You think it's successful in protecting the environment, and how is it adversely impact the human part, the human component? Is there a designation between the two, or maybe we're just looking at one, and as we move off island, and we get off this island because we looking here because we kind of never include everything, right? Because the impact, the negative impact, but I just trying to say, is it where we want it to be, the intent of this? Right now, if we looked at it when we created this process as to where we are now, when you say we bombing comments, is it where we want to be, is my question. And I would like to know you guys' personal answer from this.
Commissioner, that does call for a subjective philosophical answer as opposed to a legal technical one, of course. Ron, do you want to go first on that?
That's what I'm here for. Is these philosophical, off the cuff opinions. Are we on? We're not on my discussion questions. We don't have them put up there yet. I just generated those based on. But if you guys have it, do you have it in a handout or something? Can you see them?
Yes, they do.
Okay, great.
do have it.
Sorry, Ron, if we're stealing some of your discussion questions, but.
No, that's the whole point, I think, is that this is perfect. I base these questions on what I've heard from land use commissioners, planning commissioners, board members, land board members, and other folks that had to make decision about land projects. And what I'm seeing is that all these questions are coming up in this discussion right here before we've really even had a chance to do it. And Commissioner, I'm not sure that I'd be answering your question exactly how you meant it, but um, our law is modeled on the federal law. Federal law was first, NEPA was first, and then 343 shortly after. We were one of the first states to do it. Not every state has done it. And NEPA considers the environment to include humans. And so we are an integral part of the environment, and anything that affects us is an environmental impact. So, for example, pollution, air pollution into human lungs, um, economics, cultural and historical legacy. So that should all be considered in the EA and EIS. So I think you raise a really good question, and about have we done too much? Have we done too little? How is it going? Uh, my personal opinion, which I'm being allowed to express at this point, is that it has functioned well, and we've prevented a lot of horrible things from happening by having this process. But it's not a perfect process, and everyone wants to tweak it. Problem is, some want to tweak it one way, some tweak it the other. But that's a question that I have to come up, and I got some comments about that I could raise later, and I hope that that we can get into that.
Thank you, Mr. Terry. Some more comments or questions, Mr. Commissioner Wu?
No, and I want to thank you for your honest opinion and this and I love open green pastures. I love Maui, right? I just want to make it clear that the open space is something that I cherish, but at the same time, there's could be some consequences when we got all the open spaces and we don't have enough space for humans. And it's just my manao.
Absolutely.
Thank you. So Commissioner Carr Smith and then Commissioner Giovanni.
Thank you, Chair. I was going back to something the executive officer said about Kapa'akai and that we are the agency that needs to review and see whether it's been adequately addressed or not. Is that what you said?
Um,
And the
We-
reason I'm asking, just to clarify, is because I remember petitions in the past that we heard, and commissioners who were attorneys insisted that the petitioners go and do a kapa'akai.
I'm not. I think that what those commissioners were saying was that the petitioners need to provide the information necessary for them to do a Kapa'akai analysis. The Supreme Court is very clear that the Kapa'akai analysis cannot, and the decision on Kapa'akai cannot be abdicated to a petitioner. It has to be done by the agency itself. But the agency needs to have all of the information necessary. And we've had a couple of instances where public testimony has indicated that there may be cultural impacts that have not been analyzed or disclosed. And it is in those instances, as far as I can recall, that the commissioners have said to the petitioner, you need to go and provide us, do an analysis on the cultural impacts so that we can complete our Kapa'akai analysis.
I'll accept that for now. Thank you.
Thank you, Commissioner Giovanni.
Yeah, my question is about the expression of an EIS being stale. Hypothetically, we've seen instances where a project originally was approved or had even before it was approved, it had a EIS that was done 15, 20, 30 years ago. And then they want to propose a new project and say, well, we did the EIS already. And then there's some discussion about whether or not it's stale and needs to be updated or redone. What's the guidance that you can provide about how a commission can act when there's the potential for an EIS being old and stale?
Commissioner Giovanni, I'm going to ask our staff to answer that one. Oh, and then Ron, after Tom answers.
Yes, well, the legislature has considered that question numerous times, and they've never come up with a definition. So there's nothing in the statute or the rules that says a specific EIS technically goes stale or expires or something to that effect. So it's really up to the agency that has the current question at hand to determine if that old EIS is adequate or not. Does it address the current context of the situation? Has the project changed? So these are things that the agency needs to consider as far as the guidance. It's very specific to the situation, but just really ponder the question heavily. Does this 30-year-old analysis really relate to today's world or not?
Yeah, I just wanted to add a little bit of context to that. The Turtle Bay decision, some 15, 20 years ago, whenever that was, really added some clarity about that. Not only if a project is significantly changed, but also if the environment around it has significantly changed, such that even if a project doesn't change dramatically, the environment has changed so much that the impacts are distinct, different, more severe than they were before, which renders the EIS no longer the same project in a sense. You know, it has to be redone. We in the rules, well, the statute allows for supplemental EISs to take care of this. By the way, it doesn't allow for supplemental EAs, and that's something Scott and I used to argue about constantly. I said, if you interpret it in a certain way, if you look at it through this lens, maybe it does say that, but Scott said absolutely not. He uses the word statement, only supplemental statements. This makes it hard to supplement an EA, and therefore people are really reluctant to do it. Again, I want to go to NEPA, our federal law on this. They're much more explicit about this. They allow both supplemental EISs and supplemental EAs, and they encourage them. There's quite a few NEPA supplemental EISs. Agency by agency, they have their own policies. We have one overarching set of rules, chapter 11.200.1 that administers our EIS process. The federal government has a whole panoply of EIS rules, one for each agency. I've worked a lot with the Department of Transportation, Saddle Road EIS. I wrote those, and in fact, we did a supplemental. They have a policy that after 2 years, if you haven't started the project, and they have a definition for start that's real specific, if you haven't started the project, you need to do what's called a reevaluation. And that it's a very systematic process. If they don't do the reevaluation, if it shows that there's some changes, then you have to supplement. And I introduced this as a proposal during the update to the rules in 2016 to 2019. I lost. That wasn't wanted by the majority of people. People felt that it might engender an endless series of documents, and I get that. At the same time, there's a lot of dissatisfaction with stale documents. I would expect this to come up in the future.
Yeah, thank you for that. I think, particularly on the island of Kauai, we see in some cases environmental impact states or even EAs that were done years ago. And a key element of those analyses were the traffic impacts. Well, you go to today and the traffic is a considerably different scenario than it was at the time that original assessment was done. So are you suggesting that in a case such as that, hypothetically again, it would be up to the agency to make a determination whether or not that has to be reevaluated?
Yeah, I'll give you a specific example. You folks don't know Hilo probably very well, but there's an intersection of Kawailani Street and oh gosh, what is it? Iwalani Street. Okay, it's a place in Hilo. And we got a federal aid grant, DPW got a federal aid grant to improve this intersection. We did an EA for it. It was all good, did traffic impact analysis. 2 years later, they didn't have the money. They did a reeval. Traffic wasn't that different. 4 years later, they still didn't have the money. They did a reeval. You know what? Traffic was different. So we had to do a new TIAR for it. And that resulted in different turn signal or turn lane lengths and other features for the intersection that would more appropriately handle traffic for the next 20 years.
Thank you. I'm good.
I'd just like to comment that it is possible that a study like a TIR can be done outside of the EA or EIS, can just be requested by the agency without needing the EA to be redone. So there's the opportunity for the agency to get the right information either within or without or out external of an existing EA or EIS.
Thank you. Commissioner Miyasato, did you have a question?
I have, but thank you, Mary Alice, Tom, and Ron for taking the time out to put on this presentation. I had a question, but it was answered by Ron. But I guess while I have the floor, uh, director came on and had made a comment or an I guess additional comments towards the Kapa'akai. Could either Mary Alice or Ron or Tom kind of fall back to you, because it seemed like it was kind of contradicting what was presented at first. So could we get a little bit more clarification from your end?
Yeah, I think I might have a slightly different opinion than your executive officer on the LUC's role in your determining the acceptability of an EIS, not your role as a decision maker on a petition for a DBA. And that is that statutorily, you are not required to find that an EIS is deficient or unacceptable if there isn't a Kapa'akai analysis in that disclosure document. However, when it moves to your rules under 205, and it's your call as to whether you do have to do a Kapa'akai analysis, and you do have to get the information you need to make that analysis. So at that point, you want the petition, that's not the disclosure document, the petition to have that information in it.
I don't disagree with that statement. I think we're saying the same thing. I just said it differently.
Oh, no.
Okay, thank you. I'm going to ask a couple of questions, and then I want us to move on so that we can cover Mr. Terry's questions, and then that way we can have further questions, but at least we can move on a little bit. So my first question is, this should be a quick one. So unlike SMAs or conditional use permits, there's no hard dollar trigger for an EA or an EIS. Is that correct?
Correct. There's no trigger that's related to a dollar figure.
So it could be under 500,000, yet might require an EA or an EIS.
Yes.
Okay. And then my second question is, and this is just my civilian understanding of this confusing process. The compiling of the EIS must follow pretty strict statutory requirements on disclosure. But once that's been completed satisfactorily, the acceptance is somewhat of a more subjective, judgmental call. Or would that be almost the correct statement?
I hope not. And that's a personal view. I hope we were able to convey that you as a
Accepting authority,
when you have a final EIS in front of you, are going to look at the three areas that the statute and rules require you to look at. Whether the procedures were followed, and that means that there was a prep notice that was published, a public hearing,
a comment period.
Then when there was a draft EIS published, that comment period extended for the appropriate period of time, 45 days. In other words, those are the procedures. I think those are fairly objective, and I don't think you can, if they actually will know if they missed, and they'll probably withdraw and try to, cure that. The contents, perhaps a little more subjective because of the broad nature of those definitions that do include human impacts as well as, birds and sphinx moths and et cetera. But you can use kind of a checklist to go through whether they've met the contents. And I believe do we now require a table of contents in the EISs to annotate where in that 1,000-page document you're going to find each content?
In the next iteration of the rules, we're talking about including a checklist to show that the preparer of the document shows where in the document these items, these required items contain. Right now, we ask the consultant to tell us where it is, so it's easier to perform this
Yeah,
criteria. of
when you've got
acceptance.
literally, a 1,200-page EIS, it's helpful to have a guide to where you're going to find those content requirements, like page number, et cetera. Yeah, I will say we are looking at doing an update of the rules. We have not completed our draft. We have not submitted it to the Environmental Advisory Council. They have a statutory role in consultation of looking at any draft rules that we're contemplating for adoption. So more to come, but that's one area that we thought would be helpful in making it easier for agencies, including the commission, to be able to determine that middle second one, the one on whether the comments have been substantially and appropriately responded to, is the area that I think is subjective. And I think that commenters often feel that they did not get a satisfactory response because the response, say they're opposed to the project, and they put those, their views in their comment, and the planning firm that's drafting the comments, the agency that's drafting the comments, responds to their concern, acknowledging it, but doesn't say we're going to cancel a project. That a commenter might feel that that was didn't respond to their comments. So I think there's a lot of room for subjectivity in that one.
If I can add to that, I agree with everything that Mary Alice just said. I think the other area where there's subjectivity is, and this has happened in front of the commission several times, where someone comes in and says, you did do a traffic impact analysis, but you didn't take into account this other road that comes down in, or you did an environmental study, a runoff study, but it doesn't take into account the fact that there's a nursery reef off the coast. And then the commission has to decide whether or not that testimony is enough, or that information that's been provided is enough to put the sufficiency of the analysis into question. And that's where the discretion comes in.
Thank you. We're going to move on, and because I know there's more questions, but we still have to move on and save them for later. But wow, uncertainty really is a huge factor in costs and risk, and so this is a very important subject. So are we at where Mr. Terry goes over his discussion questions at this point?
Yeah, we can move on to that point if Ron is ready to guide that.
Chair?
Yeah,
Okay, hang on. Commissioner Carr Smith, did you have a question?
I just wondered if Ariana could perhaps do a split screen so we can see the questions and still see see Ron and the AG and the two commissioners.
I'll be right back.
Thank you.
Okay, we'll work on that, and let's try and proceed.
okay, I think that was my cue.
That's correct.
Yeah, I came up with this list of 7 questions. I think in the interest of time, we're going to go to 4, 6, and 7, although the other questions have come up a bit.
Yeah.
I want to first acknowledge, thank you guys for serving on this commission. I know it's not easy, having been on commissions before, and yours is one of the hardest ones. I was never on one this hard. So thank you for what you're doing. And I understand that this is one small part of your work, EISs, and yet it causes a lot of problems. So I hope this ends up being helpful. And before I get into questions 4, 6, and 7, I want to kind of answer Miles a little bit about what he asked about the cultural impact assessment, and I'll elaborate on what Dan and Mary Alice said. But as the preparer of an EIS, I've had to contract to a lot of cultural impact assessment specialists. And I've worked with some of the best in the business. Kepa Malley, Pulani Kanahele, Ed Kanahele, Keha Watson, Lokilani Brandt, some really great people. And they have written some wonderful materials. One thing that I've sometimes struggled with each of these is getting them to sort of go beyond an ethnography, which is their primary work, into an impact analysis, and in cases where it's necessary to address the Kapa'akai findings. And in contrast to maybe what Mary Alice and Dan said, I think it's important for the EIS preparer, at the very least, to draft some Kapa'akai findings. I understand that in some senses these are premature, and Dan wisely said, these shouldn't be, just brought to the commission whole like a meal, and you guys eat it. You have to make your own findings. But I think it's helpful to have somebody draft those. And you're free to disagree with them or modify them, but without something as a basis that's been done through the cultural impact assessment preparer and then through the EIS preparer, it makes your job a lot harder. And I'll leave that up to you how you want to do it. Now I want to kind of move on to question 4, because this has come up a lot. How do you know whether you need to do more work on an EIS, right? People are saying, hey, that's not enough. That's not enough. You guys haven't really answered the question. There's not enough science on this. And I want to walk you through some experiences I had, and then discuss a legal background. And I know your AG might want to cut my mic. Mr. AG, I'm not a lawyer. I'm not giving legal advice, and my legal review may be somewhat juvenile, but feel free to step in. But I have studied this quite a bit, and I know you've had to face this recently with regard to the Keauhou aquifer. There are folks that say there's just not enough information about that aquifer. You're asking us to make decisions, and we feel like we don't have enough information. The EIS didn't provide it. Well, I just want to say you're not alone. In my EIS process, we came up on this with the Saddle Road. There was the issue that some of you may remember of depleted uranium, that some of the shells that were used on the range, they discovered had this uranium. It's a very weak form of uranium. That's why they call it depleted. It's not highly toxic, but if it gets pulverized all over the place and you breathe it, it is very much not good for you. And we were proceeding to finalizing EIS, and we didn't have information about this. So we commissioned a study that was, frankly, quite expensive, and it took quite a while to get, to see if there was any traces of depleted uranium anywhere outside Pohakalo training area where this road would go through. And after a year of study, we said, no, we can't pick up one trace of it anywhere in Kona or Kohala. And if it blew there, it's in quantities that are so small that they're undetectable. And we got comments on the EIS that says that's not enough. You need to do it different places and with different methodologies and that sort of thing. So we had to face that. We had to make a decision about, did we have enough information or not? Have had other projects where our traffic models were questioned. Did you study enough intersections at enough times, at enough places in the future, under enough scenarios, or not? And we've been faced with these conundrum. As a commissioner, I have faced this problem myself on Mauna Kea with questions about the deep hydrology of Mauna Kea. If any of you guys have followed that, it's wild. The underground of Mauna Kea is insanely complicated. Nothing like what we had ever envisioned before. But we only have a glimpse of this from some sort of seismic type studies. And people would say, well, do you have enough information to allow the 30-meter telescope to be built if you don't know exactly what the inside of Mauna Kea looks like? So we had that. And I think Tom went well, and Mary Alice went over the acceptance criteria in EIS really well. And I'm not going to belabor what it says in chapter 343. But I think there's still a lot of gray areas. And I want to again go to NEPA and both technical guidance and case law, which provides some guidance on this, paralleling at EA, and I think our HRS 343. And they talk about things like a full and fair discussion, analytic but not encyclopedic, presented in plain language, proportionate to the impact, supported by evidence, prepared with scientific integrity, and disclosing responsible opposing views, supported by credible, when they are supported by credible scientific evidence. And I think the key that NEPA says is you got to summarize existing credible scientific evidence and the best available scientific information, and it should not be speculative. Okay, but sometimes that information isn't out there. When there's not enough information relevant to reasonably foreseeable significant impacts, the Council on Environmental Quality Regulations, in other words, the NEPA's equivalent to our regulations, says this, that the agency must either, one, determine that the cost of obtaining such information is exorbitant, or the means to obtain it are not known, or you need to obtain that information and put it in the EIS. And I postulate that maybe that's the requirement that you poor commissioners and staff at LUC sort of have to meet too. If somebody's telling you that we just can't get that information, it's just not out there, you have to say, you have to do a little bit of a cost analysis. Well, is it impractical? Is it impossible? Is it exorbitant in cost? If not, you need to require it. The federal courts were really clear up until about 2000 that you didn't do an EIS to get a bunch of extraneous background data. And that if it was, this other data was just too expensive or infeasible, you could forego its collection in the EIS. But you needed to make a statement that the information was incomplete or unavailable, and a statement of the relevant existing credible scientific evidence. And after about 2000, I looked at a 2017 professional legal review of case law. It said that courts were kind of not putting up with that anymore. They weren't having it. They weren't all about that. They wanted to see, they were in fact sometimes saying, we want to see a fresh statement of scientific evidence. And judges, rather than scientists or agency officials, were saying, we need a crack at it too. And if we don't think that there's enough information, we're going to ask for it. There was a lot of concern among jurists that this exceeded the courts, substituting their opinion for that of the agency was really exceeding their authority. In about 2017, and I think you can do the math and figure out why I'm saying that, that trend seems to be reversing. And courts are less and less second guessing agencies on this. And so, there's sort of a ping pong through history of how hard you have to look. Is it hard or harder or impossible at this information? So, in my judgment, should an EIS be normally expected to do a multi-year, multi-million-dollar groundbreaking scientific study if there are opposing views as to impacts? I don't think it's generally supported by NEPA or by Chapter 343, but each individual case is unique, and legal review and even court decisions are going to be necessary to determine that, even here in Hawaii. So I know that was kind of a long comment. My others aren't so long, but I wonder if there's any questions about that.
Mr. Terry, please proceed. we're probably gonna take a break at 12:15 and, Commissioner Giovanni will have to excuse himself as well, but, we'll see how much we can accomplish in 15 minutes and then we'll take a 10-minute break.
If
Yeah,
I
I
could
think,
just add very quickly, the EIS process does have a place to address unresolved concerns.
that's
And
right.
so these things are supposed to be discussed that you don't know or that it's not resolved. So it's not completely left as a void. It has to be discussed in an EIS.
Oh, no, absolutely. And also responsible opposing views. The things that NEPA said, many of them are in 343. Another question I got is that, someone has said, what is it here? Number 6, there's, these rules, even though they've been amended and the law are 50 years old, and have they met their original intent? I think we answered some of that. Or has the purpose been frustrated and co-opted? And how have they evolved and how could they evolve better to function? And I just want to say, stress again, I think there's significant room for improvement. And hey, we tried in the 2019 update. We did a lot of tweaks. And I think I want to say that our process with public engagement was so robust that by the end of the rules, we had both sides of the aisle agreeing on the rule changes. We had very little pushback from the final version of rules. We left a lot of good stuff out. Like I said, the supplemental EAs I wanted, we left that out. But I think we made a lot of tweaks. And now I just want to mention we have the de minimis exemption, which I think Tom just maybe barely mentioned. But you don't have, an agency doesn't have to do anything if it's a super minor project. We took care of comment bombing by having a different way to address them. We don't have to write 1,000 or 3,000 individual letters back. We said that draft EISs must have a public meeting. We felt that was really important. And the public was asking us for more engagement. And so that's now a requirement, one public meeting for draft EIS. They're pretty infrequent. I don't think it's too much. We also said you must accept oral testimony at the meeting, and you must be sure to address oral testimony because in Hawaii we have an oral tradition and we wanted to respect that. We also did an affordable housing exemption. And I think I'll get into that a little bit later. But I think the statute needs to be changed. And in my humble opinion, we need to allow supplemental EAs, and we need to change the definition of action to narrow the scope of 343. Right now, it is so broad, it literally covers, if you take the rules at face value, it covers buying a box of paper clips. It covers promoting someone from clerk typist 1 to clerk typist 2. It covers fixing a pothole. And I think those types of things should be excluded, not exempt, because as Mary Alice points out, exemption means you're in the law, but there's some procedures, but they should be excluded. That's my opinion. And also we should require a record of decision at the end of every federal EIS. Right now, EISs contain mitigation that is not always captured in the end. I look at projects I worked on and I go, where's the endangered species exclosure? I thought we were going to do that. No, they value engineered that out. I commend the Land Use Commission for your process that takes mitigation from the EIS and incorporates it in conditions. And you're one of the agencies that does this. Not every agency, not even most agencies do this. Most mitigation in EAs and EISs somehow doesn't get accomplished. So that's my thought about that. Is there time for questions, Brian, or should we move on?
We're at 12:08. We want to go to 12:15, and then I don't think there's much more after that other than questions. So see what you can do until 12:15, and then we'll take a 10-minute break, and we'll try to plow through as quickly after that as we can.
Okay, I hope you can remember, if you have any questions, you can remember them after the break. But yeah, the last one I want to cover is question 7. And this is, a shot across the bow of the whole EIS process. Is it basically just a roadblock to solutions? And should there be some types of projects, even if they use state and county land or funds, or even if they're in the conservation district, or even if they're in Waikiki, or whatever, shoreline setback, that should be just excluded from chapter 343? It's a very provocative question. I think it's a really interesting one. And the first thing that comes to mind, of course, is housing. How do we create more housing? An EIS can take 3 years, and it can cost $1 million. What an obstacle that can be to housing. Certainly, we want to protect the environment. It's not like that's not a priority, but is there something that we should exclude from this and just make it easier? And I want to say that that's a political decision that's kind of outside of Chapter 343. If you want to say some projects that significantly impact the environment don't get a very hard look, that's a significant political decision to make. It may be necessary, but it is that. I want to point out that the 2019 rules did exactly that for affordable housing projects that met certain criteria. And not projects that come before you, because they had to be in the state land use urban district, and they had to meet zoning requirements that at least allowed some type of housing. You want a multifamily in a single family zone? Fine, that's fine. You don't have to do an EA for that. It also had to make sure there was no significant archaeological resources, no EV, no cultural practices that were going to get harmed, and no endangered species. And it wasn't in a super hazardous area subject to natural hazards. So it kind of developed this concept of a super exemption. You couldn't just exempt something with just a signature on a paper. You had to do some research on it. You had to go out there and do an archaeological survey, do a botanical survey, and bring it all into the exemption process. But that could be done in a matter of 30 days for a minimal cost, rather than an EA that might cost 100 grand and take 6 months, or an EIS that could go longer. And that is in the law. That provides a template for future actions if people are willing to go there. You got to say that I generally feel that excluding certain types of activities from the requirement for an EIS is a bad road to follow, because it's a slippery slope. But on the other hand, I think that the affordable housing exemption worked out well. I have no objections as a strong environmentalist to it. I think it's okay. And I think people need to be thinking creatively in the future about that. That's it.
You're gonna pass on number 8, or you want to save that till after the break?
This is really just a question for you. I wasn't going to say anything. I've talked enough. So I'd love to take that up after the break if you like.
Great. Okay, we'll take a 10-minute break, and then I think we'll have a few short closing comments after that, and I think we'll be almost done. Thank you. Okay, we'll come back at 12:25. Thank you, everyone. Okay, we're going to be back, and we are going to continue with Mr. Terry for question number 8, I believe.
Yeah, well, again, this was just a kind of an open-ended question to you folks. I don't know if you want to start with that. I guess I think Tom went over really well the requirement for the difference between an EA and an EIS. You have to have these significance impacts. You can jump straight ahead to an EIS if you so choose, because you think there's likely to be significant impacts. But if there's no significant impacts, if you're pretty sure of it, then you can just stick with an EA. Are there any circumstances where you folks feel that, hey, maybe this is just an EA? Most of them are EISs, but this is just an EA, making it simpler. And do you do a systematic analysis of significance of impacts? And I think I don't know if that's a staff or a commissioner question.
I mean, from the staff standpoint, we do an analysis based on the factual information that's been provided to us, and we do make a recommendation with regard to whether or not an EA or an EIS is required, but it's up to the commissioners to make that determination. We've actually never gotten into that situation. Usually what most developers or petitioners will recognize that under current law, they may have to do an EIS. And, you know, for having been on both sides of the table on this, when I was working for developers, sometimes it's just a risk analysis. In other words, you're looking at whether or not you can get away with an EA or an EIS, and the developer may make a determination that even though they might be able to get away with it, it's not worth the time that would result from an appeal if there are other people out there questioning it. And it would be more efficient, even though it's more expensive, to do the EIS. It's almost a cost benefit analysis that these developers do. And very often a developer will come in and talk to staff to see what we think about their chances of getting away with an EA. We never give them a definitive answer because it's always up to them to make the decision, but we do point out the risks.
Yeah, well, that's
Office of Planning does the same thing, right? You have developers come in and talk to you about how they should proceed.
Yes, occasionally and in a general way, but we probably are even,
Not you, Tom, but the land use division at OPSD.
You know, I don't think that question comes up because when we're talking to developers, normally it is when they're contemplating putting a petition in for a DBA, which would be after they have completed their disclosure process.
So they don't always listen to us and go and talk to you when they have questions.
Mr. Terry, did you have some more comments about that?
just a little bit. Yeah, I mean, I understand the risk analysis part, and I've engaged in that myself. We did an EIS for a transfer station in Ka'u because we felt that the opponents would sue for an EIS. We already knew that. They'd already said that. And it's one of the easiest lawsuits to win, at least in federal court. Judges will almost always say, well, you know, where there's smoke, there's fire. If everybody feels that strongly about it, why don't you guys just do an EIS? And so, you know, this was an agency project, and we made that choice to go that way. The agency did. But it does have a lot of high cost implications, and, you know, it adds to the price of things. I think it's nearly always appropriate for the projects that you have. I mean, some of the big ones I see come in, my goodness, I can't see how they would not be an EIS, but I can envision a 20-acre charter school where they're going to do, you know, a whole bunch of things on the school property, in an old nursery that has already been fully impacted, where there's no traffic impacts, there's no endangered species, there's no archaeology. And if that situation came up, I would hope that the automatic answer wouldn't be, tell them they probably need to do an EIS, because that'd be someone with limited funds, clearly limited impacts, and maybe a lot of support in the community. But you know, I think there's some projects in between there some housing projects that might be over 15 acres. It's funny, all my landowner friends seem to have 14.99 acre properties. It's kind of weird. But there might be some, 20, 25 acre housing projects that don't bump into significance. Although I realize that NIMBYs can be extremely effective in their legal challenges.
Thank you. So I'm going to turn it back to Director Evans. If you have, I think, one final slide or any other closing comments, and then we'll have time for some very quick, brief questions. Thank you.
Thank you, Chair. Actually, I just want to say thank you for inviting us. We welcome this kind of an opportunity to present, the Chapter 343, since the Land Use Commission has several significant roles in the Chapter 343. You get petitions to serve as the approving agency. You make a decision, determine what level of review that applicant needs to go through. And then when you get the final EA or EIS, most likely an EIS, you make a decision about the acceptability of the final EIS. And I understand how challenging that is, because the public often wants to stop projects that they don't like at the environmental review step. And and because every single one of those pathways, including exemptions, has the opportunity for a judicial challenge once a decision has been made about acceptability. Your decision does have to have some basis in the chapter and the rules, in order that when it's challenged, sometimes as a way to slow down a project that an opponent doesn't want, that you can point to your basis for making that decision. We would be happy to come back again at some point if the commission wants to review this. We'll be happy to bring back our draft rules when they've gone to our Environmental Advisory Council. And this would be after the Environmental Advisory Council has provided their input on that. I don't think it'll be significant changes, because we started out thinking of it as housekeeping to bring the rules into compliance with Act 152, Session Laws of Hawaii 2021. So we're a little overdue in doing that, but we are taking that opportunity to try to clarify things that may have generated questions since the new rules were adopted in 2019.
Director Evans, appreciate that offer very much. And with that comment in mind, are there any brief questions, noting that they will be able to come back at some later date, but for now, are there any brief questions from commissioners? Okay, seeing none, and I don't. Yes, I have. I tried to contact Miles. Miles, do you have any follow-up questions? Because I can't see you on the screen. Oh, there you go.
No, I'm fine. Thank you. And thank you for the presentations.
Director Evans, Mr. Eisen, Mr. Terry, we really appreciate what you have presented to us today. It was very important, very enlightening, and very fascinating. And thank you for helping enlighten us with your vast experience. We really appreciate it. And also members of the public that did watch, we appreciate that. And at this time, I'm going to once again ask, are there any members of the public who wish to provide new or additional testimony on this matter?
Seeing none, using the Q&A feature, Chair.
Thank you, Ms. Kwan. Are there any members of the public here in person who wish to provide new testimony on this matter?
Seeing none, raising their hand, Chair.
Thank you. This now concludes our meeting. Is there any further business to discuss? Seeing
Chair, may
none?
I make a brief comment?
Yes, please proceed.
Okay, on behalf of the LUC staff, I'd like to recognize our executive officer, Daniel Oradenker. He was recently honored with the Manager of the Year Award at the DBED Service Awards on August 5th. We're proud to see his leadership and dedication recognized, and we truly believe that LUC would not be where it is today without his guidance and hard work. Thank you, Dan.
Thank you, Ms. Kwan. Congratulations, Mr. Ordenker. Do you want to make some comments?
Yes, thank you.
Microphone.
Okay, there you go. I've said this many times. I would be nothing without my staff, and I truly appreciate them. Thank you.
Thank you, Ms. Kwan. Thank you, Mr. Ordenker. There being no further business to discuss, this
Sure.
meeting, oh,
Sorry.
go ahead.
Um, I wanted to ask a procedural question about future agenda items. How far in advance does a commissioner have to ask the chair to add an item to the next agenda?
Mr. Ordenker?
It takes us about a week to get our agendas written and approved, and then we have to post them within six or seven six working days. So you're probably talking about at least 2 weeks.
Okay, thank you, everyone. This meeting is now adjourned.